Assalamualaikum warahmatullahi wabarakatuh. My name is Sarah Nuraisha Lulu binti Muhammad Zahrir and my metric number is 060175. So today I will be presenting on the topic of crime of aggression. So for the overview, number 1 will be the introduction, number 2 will be the crime of aggression, number 3 will be the historical background, number 4 will be the International Criminal Court's jurisdiction, number 5 will be the cases, number 6 will be the conclusion. So for the introduction, when a political or military ruler of a state calls for the use of violence against another state, provided that the use of force in some manner, shape, or direction breaches the United Nations Charter, that act is considered an act of aggression. The crime of aggression is one of the 4 crimes included within the International Criminal Court's ICC purview. So the violation listed in Article 5 of the Rome Statute was suspended pending consensus among the state parties on its interpretation and usage rules. Next, the crime of aggression, an act of aggression as defined under Article 8, Clause 2 of the Rome Statute and Article 8, Clause 1 of the Rome Statute. So Article 8, Clause 2 of the Rome Statute means the use of armed force by a state against the sovereignty, political independence, or territorial integrity of another state, or in any other manner inconsistent with the United Nations Charter. As for Article 8, Clause 1 of the Rome Statute, defines a crime of aggression as where a person who is in a position of power to exercise effective control or direct the political or military action of a state, and such person plans, prepares, initiates, or executes an act of aggression, which because of its character, gravity, and scale constitutes a violation of the United Nations Charter. So regardless of a declaration of war, the following acts shall, in accordance with the UN General Assembly Resolution 3314 of December 1974, qualifies as an act of aggression, which is the use of armed forces of a state to A, invade or attack the territory of another state, or resulting military occupation, however temporary, or any annexation with the use of force on the territory of another state or part thereof. B, bombard or use of weapons against the territory of another state. C, blockade the ports of coasts of another state. D, attack the land, sea, or air forces, including the air or marine fleets of another state. E, where the armed forces of a state within the territory of another state on the agreement and using such force in contravention of such agreement of an extension beyond its period of termination. So the action of a state allowing the armed forces of another state to occupy its territory in order to commit an act of aggression against a third state, and where state sends armed bands, irregular groups, or mercenaries to carry out acts of armed violence against another state to such extent that it amounts to the act listed above or substantial involvement in it. Next, for the historical background, prior to World War I, Karl von Clausewitz predicted that state politics would simply continue. This exemplified the belief that going to war was a state-inherited right. The 1919 Peace Treaty of Versailles, which deemed war an act of aggression to be the highest transgression against both international morals and the integrity of treaties, reserved this notion. In 1928, the Kellogg-Briand opposed the use of violence to resolve international conflicts and denied it as a weapon of national strategy for interstate relations. So the Nuremberg tribunals, which were founded by the London Charter shortly after World War II, made it illegal to wage an aggressive war. The Nuremberg tenets were acknowledged as international law by the United Nations General Assembly (UNGA). The 1948 Tokyo ruling was based on the Nuremberg Principle as well. So the UNGA rejected the idea that starting a war was an inherent right of a state and instead declared that it may constitute an international crime in specific situations by recognizing the London Charter as international law. So the crime of aggression is interwoven with other historical arguments that remain unsolved within the field of international law, which prove to be impossible to define. Despite this evolution and the global understanding that war must be denounced as an international crime. So, as a result, the concept of the crime of aggression was ratified by the UNGA in 1974, although its normative usefulness was undermined by the definition's abundance of out-of-date concepts created during the Cold War. This was partly because the state utilized the idea as a strategic asset that it wanted to control in order to use it against its adversaries on the global stage. Since 1947, no further suspected masterminds of the aforementioned atrocity have been put on trial, leaving the Nuremberg tribunal's legacy unrealized. So, according to the Statute of Rome, the crime was acknowledged as one of the most serious crimes of concern to the international community. However, the ICC was unable to exercise its jurisdiction because the crime was still not clearly defined. In order to address the fundamental issues with the definition of the crime of aggression, a special working group was established during the first session of the Assembly of State Parties in 2002. The definition accepted at the Kampala Review Conference in 2010 was ultimately derived from the Special Working Group ideas on the crime of aggression, which were finalized in 2009. So the International Criminal Court's jurisdiction. So the International Criminal Court was founded in 2002 in order to remove the protection that the criminals of the most heinous crimes that afflicted the international community obtained and to prevent similar crimes from occurring in the future. Anybody can be tried by the ICC anywhere in the world, but a resolution by the UN Security Council is required to indict criminals who are nationals of a country that has not ratified the ICC statute. The ICC has jurisdiction over a number of crimes, including genocide, war crimes, crimes against humanity, and the crime of aggression in the preamble to the ICC statute. These crimes are referred to as the severe crimes that put the security, peace, and well-being of the international community at risk. The words peace and justice, however, are not defined in the preamble, leaving opportunity for interpretation. So, according to Article 12 of the Rome Statute and the notion of jurisdiction, Russian temporis, for example, temporal jurisdiction, the ICC is only permitted to look into crimes that occurred after July 1st, 2002, the date that ICC statute entered into force. So the method for establishing the court's jurisdiction, the state parties referral, and the ICC's proprio motu authority, which is an action performed without a formal request, and the UN Security Council's referral are all outlined in Article 15. So what can the ICC prosecute? So the crime has no retroactive impact, and the ICC can only bring charges for crimes of violence that were committed a year after ratification or acceptance of the amendments by 30 states parties. So who can the ICC prosecute? Only crimes committed on the territory of countries that have ratified the Article 8 Peace Amendment or by residents of those countries will be punishable by the court if a case is submitted by a state or by an ICC prosecutor. The Rome Statute gives parties the option to exit out or opt out at a later date. Therefore, the extent of the ICC's authority may change over time. But regardless of whether a state has chosen to accept or reject the amendment, the ICC will have the right to bring charges if the UN Security Council refers a case to it. So, according to Article 8.1 of the Rome Statute, only those in a position effectively to exercise control over or to direct the political or military action of a state are subjected to this prosecution. This implies that the only people who can be prosecuted are those who hold official state command posts. So for the cases, the Nuremberg and Tokyo Tribunals case law contains examples of trials against those who committed the crime of aggression. Rudolf Hess was the only defendant at Nuremberg who was found guilty only of crimes against the peace. Hermann Göring and the other defendants received sentences for both crimes against the peace and conventional war crimes. Hideki Toho was one of 23 defendants found guilty by the International Military Tribunal for the Far East of waging an aggressive war. Since 1946, there haven't been any national or international prosecution for purported crimes of aggression, while the Security Council has occasionally found that, for instance, South Africa and Israel, among others, had engaged in such behavior. So, new trials for alleged crimes of aggression on a national and international level are now possible according to the Kampala amendments to the Rome Statute. However, several analysts like O'Connell, Niazmatov, and Milanovic doubt that anyone will ever be tried for the crime of aggression as described by the Rome Statute due to the challenging processes for prosecuting the crime of aggression and the implementation of the changes. So next, for the conclusion, promoting both justice and peace is the International Criminal Court's main goal. The ICC has received harsh criticism for doing neither, but it also faces significant structural and political challenges. It is constrained by institutional constraints and limited resources on the one hand, and subject to governmental manipulation on the other. Despite all of this, the ICC has the potential to be a beacon for advancing global justice and peace by deterring criminal activity, since those who commit significant crimes know that they face prosecution. So it is said that the ICC's ability to contribute to global peace and justice depends on the institutional authority and backing it has from the nations. So basically, those are all the points and materials that I have been able to gather for the crime of aggression. So basically, to conclude that for the crime of aggression, I have mentioned the historical background, the jurisdictions of the International Criminal Courts, what the ICC can prosecute, who can the ICC prosecute, and I have given some cases for the crime of aggressions. So I think that is all from me. Thank you very much for listening.